Hello, this presentation relates to the authority's guidance on targeted financial sanctions as published in the guidance notes. The content will focus on providing a detailed introduction to targeted financial sanctions or TFS, including an overview of the TFS framework in the Cayman Islands, the definition of designated persons and entities, the obligations of financial service providers, an explanation of two key concepts within the TFS framework, namely exemptions and licensing, and a broad overview of CIMA's role as it relates to TFS. Targeted financial sanctions are a specific type of financial sanction with stated objectives, one of which is the prevention of terrorist and proliferation financing. As defined by the Financial Action Task Force, the term TFS means both asset freezing and prohibition to prevent funds or other assets from being made available directly or indirectly for the benefit of designated persons and entities. Where the financial sanction takes the form of an asset freeze, it is generally prohibited to 1. Deal with the funds or other assets belonging to or owned, held or controlled by a designated person or entity. 2. Make funds or other assets available directly or indirectly to or for the benefit of a designated person or entity, or to engage in actions that directly or indirectly circumvent the financial sanctions prohibitions. This raises the question, what is the difference between sanctions and targeted financial sanctions? Sanctions are prohibitions and restrictions put in place with the aim of maintaining or restoring international peace and security. They may be aimed at certain people and targets in a particular country or territory or some organization or element within them. Targeted financial sanctions, however, entail the use of financial instruments and institutions to apply coercive pressure on specific parties in an effort to change or restrict their behavior. Sanctions are targeted in the sense that they apply only to a subset of the population. Financial sanctions are restrictive measures put in place to limit the provision of certain financial services and or restrict access to financial markets, funds, and other assets to persons or entities. They are generally imposed to 1. Coerce a regime or individuals within a regime into changing their behavior or aspects of it by increasing the cost on them to such an extent that they decide to cease the offending behavior. 2. Constrain a target by denying them access to key resources needed to continue their offending behavior, including the financing of terrorism or nuclear proliferation. 3. Signal disapproval, stigmatizing and potentially isolating a regime or individual, or as a way of sending broader political messages nationally or internationally. And or 4. To protect the value of assets that have been misappropriated from a country until these assets can be repatriated. TFS which are applicable in the Cayman Islands are imposed by the European Union, the United Nations, the United Kingdom government, or in the Cayman Islands, His Excellency the Governor imposes TFS. Official sanctions orders applicable in the Cayman Islands are published in the Cayman Islands Gazette. Some key pieces of information to take note of as we go through the presentation. His Excellency the Governor is the competent authority for the implementation of TFS in the Cayman Islands. The Governor delegated the function of receiving reports to the Financial Reporting Authority, the FRA. All reports relating to TFS should be made to the Governor through the FRA. The Sanctions Coordinator of the FRA is responsible for coordinating the implementation of TFS. The UK's Office of Financial Sanctions Implementation, OFSI, publishes a consolidated list of sanctions applicable in the Cayman Islands. The FRA's website provides a link to the consolidated list of financial sanctions targets issued by the UK's OFSI. The FRA maintains a Cayman Islands domestic consolidated list of designated persons by the governor. FSP should be mindful of sanctions implemented by the Office of Foreign Assets Control, OFAC. In some cases, the lists produced by OFSI and OFAC have the same designations. The United States' financial sanctions are not applicable in the Cayman Islands. However, they do have far-reaching extraterritorial effect. This means that even if an institution is not operating, incorporated, or constituted in the United States, OFAC sanctions may still be applicable. FSPs should be mindful of their geographical exposure and seek legal advice for their exposures to TFS emanating from third countries that are not specifically enforced in the Cayman Islands. Designated persons and entities are established through the designation of sanctions. Financial sanctions notices advise of the addition or removal of a designated person or entity from or amendments to the consolidated list or local designations made in the Cayman Islands by the governor. For definitions of designated persons and entities, the specific designation lists can be found in Schedule 4A of the Terrorism Law and Part 1, Section 2 of the Proliferation Financing Prohibition Law and the relevant Overseas Orders in Council OOICs. FSPs are required to have in place and effectively implement internal controls and procedures to, without delay, ensure compliance with the obligations arising from the designation or delisting of a person or entity. This includes putting systems in place for 1. Regular ongoing monitoring of the applicable TFS in place, including local designations. 2. Review clients against the lists of designated persons and entities, the consolidated lists. Screening should also take place at the commencement of any business relationship. 3. Implement regular and ongoing employee training and assessments to ensure adequate knowledge and handling of TFS matters, sanctions obligations, and compliance standards. FSPs are also required to have in place procedures for ongoing monitoring of business relationships or one-off transactions for the purposes of preventing, countering, and reporting terrorist and proliferation financing, and to extend to allowing for the identification of assets subject to applicable TFS. Regular reviews and updates of TFS policies and procedures to ensure they remain fit for purpose and are enforced is required. 5. Develop and foster a culture of compliance, and develop a comprehensive program to comply with the applicable laws and obligations and to prevent and report money laundering, terrorist financing, and proliferation financing. FSPs have clear obligation as it relates to the freezing of assets unless licensed by the governor. FSPs are required to freeze any accounts, funds, other assets, or economic resources belonging to, owned, held, or controlled by designated persons, entities, without delay and without prior notice, and report immediately to the competent authority. We will discuss reporting shortly. It is a criminal offense not to freeze funds or other assets belonging to, owned, held, or controlled by a designated person or entity. Please refer to the guidance notes for the interpretation of the term funds or other assets. The freezing of assets extends to all funds or other assets, including virtual assets that are owned, held, or controlled by the designated person or entity, and not just those that can be tied to a particular terrorist act, plot, or threat. Those funds or other assets that are wholly or jointly owned, held, or controlled directly or indirectly by a designated person or entities, and the funds or other assets derived or generated from funds or other assets owned, held, or controlled directly or indirectly by designated persons or entities, as well as funds or other assets of persons and entities acting on behalf of or at the discretion of designated persons or entities. As it relates to the unfreezing of assets, upon becoming aware or receiving notification advising that a person or entity is no longer designated under a sanctions regime, an FSP must, without delay, confirm whether they have frozen funds or other assets of any such person or entity, verify that the person or entity is no longer subject to the asset freeze, remove the person or entity from the FSP's list of persons or entities subject to financial sanctions, and unfreeze the funds or other assets of the person or entity and reactivate the relevant accounts. The FSP is required to submit notification to the person or entity that the assets are no longer subject to an asset freeze and notify the governor through the FRA of the actions taken. FSPs also have clear legal obligations for reporting and recording matters related to TFS. FSPs must disclose to the governor through the FRA via the Compliance Reporting Form, the CRF, details of any frozen funds or other assets or actions taken in compliance with the prohibition requirements of all applicable sanctions, including attempted transactions. At a minimum, FSPs should keep the following information about any match. 1. The basis or other grounds which triggered the match, example a hit provided by screening software. 2. Any further checks or inquiries undertaken. 3. The associated sanctions regime. 4. The persons involved, including any members of compliance or senior management who authorized treatment of the match as a false positive. 5. The nature of the relationship with the person or entity involved, including attempted or refused transactions. And 6. Subsequent action taken, example freezing of funds. A compliance reporting form or CRF must be completed when making a report to the FRA. The CRF should be used when reporting suspected designated persons, frozen assets, and suspected breaches of financial sanctions. This is what the form looks like. Other obligations of FSPs. FSPs should ensure that payments are not directly made to or for the benefit of a targeted person or entity. FSPs should familiarize themselves with their legal and other obligations and, where necessary, seek independent legal advice. FSPs must take reasonable steps to ensure that a person or entity identified as designated is the same person or entity as that on the consolidated list or the local designation made in the Cayman Islands by the governor, by verifying the name with other identifying information. If an FSP is unsure whether it is dealing with a designated person or entity, then it should consider requesting additional information from the client. An exemption to a prohibition applies automatically in certain defined circumstances. Asset freezing legislation generally permits the following payments into a frozen account without the need for a license from the governor, provided those funds are frozen after being paid into the account. 1. Any interest or earnings on the account and/or any payments due to a designated person or entity under contracts, agreement or obligations that were concluded or arose before the date the person or entity became sanctioned. The legislation also generally permits the crediting of a frozen account with payments from a third party without the need for a license, provided that the incoming funds are also frozen and that the governor is informed of the transaction without delay. A license is a written authorization from the governor permitting an act otherwise prohibited under the sanctions. Some common licensing grounds found in the Overseas Orders in Council are for basic needs, legal fees and disbursements, fees or service charges for routine holding or maintenance of frozen funds or other assets, satisfaction of prior contractual obligations of the designated person or entity, and extraordinary expenses. Satisfaction of prior contractual obligations of the designated person or entity and extraordinary expenses. It is a criminal offense for FSBs to engage in transactions or attempt to transact with a designated person or entity without obtaining a license. Any person seeking a license for the release of funds or other assets which are subject to an asset freeze is required to submit an application to the governor using the prescribed form. The application must be supported by evidence to demonstrate that all the licensing criteria are met, which include the licensing grounds being relied upon, including supporting arguments, full information of parties involved in the proposed transaction, ultimate beneficiary of the transaction, complete payment route including account details, and amount of the proposed transaction. This brings us now to CIMA's role within the TFS framework. The authority in its role as regulator for FSBs assesses whether persons or entities under its regulatory laws are aware of applicable TFS and their compliance obligations. The authority also reviews regulated entities' reports and returns, paying special attention to persons, entities, or countries listed on any autonomous list of designations and applicable international TFS. During an inspection, the authority will test the effectiveness of systems established to observe and comply with TFS in effect. And as part of its regulatory function, the authority monitors compliance of supervised entities with applicable sanctions obligations. Additionally, CIMA, in the course of its duties, will file a report with the FRA if there is any evidence or suspicion of any sanctions breaches by a regulated entity. And let's not forget, the governor is the competent authority for the implementation of TFS in the Cayman Islands. All reports relating to TFS should be made to the governor through the FRA. For additional information and further reading, please review the guidance notes, the FRA's industry guidance, the FATF recommendations, the consolidated list, and all relevant legislation, including the AML regulations, the terrorism law, and the proliferation financing prohibition law. Should you have any questions, please do not hesitate to contact us at contactpolicy@cima.ky. Thank you so much for your attention.